Welcome to this conversation for Instituto Fe y Libertad. My name is Carol Rios de Rodriguez, and today we have the pleasure of talking to our friend Sam Gregg. Dr. Samuel Gregg is the research director at the Acton Institute. He has written and spoken extensively on questions of political economy, economic history, ethics in finance, and natural law theory. He has an MA from the University of Melbourne and a Doctor of Philosophy degree in moral philosophy and political economy from the University of Oxford. For the past months, Sam has been working on a new book titled The Essential Natural Law that will be published by Fraser Institute. Today, he will be sharing with us a little about what we can learn from his upcoming book. So we're so excited to be able to interview you again. Thank you, Sam. And thank you for sharing this time with us.
My pleasure.
So I was sort of Googling definitions of natural law. And here's one from Investopedia. It says, natural law is a theory in ethics and philosophy that says that human beings possess intrinsic values that govern their reasoning and behavior. And then the Stanford Encyclopedia of Philosophy says that natural law theory is a label that applies to theories of ethics, theories of politics, theories of civil law, and theories of religious morality. So, how do you define natural law?
Well, natural law has been given many definitions since Aristotle and Plato. So the way I typically define it is natural law is nothing more than right reason. Right reason. So what do I mean by that? What I mean is that human beings have reason, and our reason is capable of knowing truths, economic truths, scientific truths, political truths, but above all, moral truths and philosophical truths, which means that natural law is about essentially using our reason to discern and know what is good and what is evil, and then acting in such a way that we realize that good through acting, through choosing, through making free choices, and not choosing to do evil. So that I think is essentially what natural law is. It's really essentially ethics. It's an ethical theory, but it's based upon a particular understanding of human reason and a particular understanding of the nature of free choice. And it has particular significance for how we understand the nature of human action and the purpose of human action. So natural law says that all human actions have an object, and that we use our reason to discern what it is, what good we are trying to realize in any given situation, and then we actively choose it. And the goods are not whatever we want them to be. The goods are things that are identifiable as rationally good for all humans in all times and all places. So an example would be something like truth. Truth is always to be preferred to error. Health is always to be preferred to sickness. Work is always to be preferred to being lazy. Beauty is always to be preferred to that which is ugly. So natural law holds that there are these objective goods that we can know, and then we try and realize through actively choosing them. So natural law, I like to say, it takes reason very seriously, but it also takes free choice extremely seriously. The other thing to keep in mind is that if you look at ethics per se, if you're looking for the sort of the fundamental division in ethics, it's really between those people who believe that there is truth, we can know it, including moral truth, and we can actually choose it and incorporate that into our lives, and those who adhere to what you might call various schools of skepticism. By skepticism, I don't mean the healthy attitude of saying, well, I'm just going to need to think more about that before I accept what you say is true. By skepticism, I mean the position that we really can't know anything. We can't really fundamentally know anything through our reason. Our reason is just purely instrumental. What drives us is not our reason and our capacity for choice, but essentially our emotions and feelings. Now, natural law takes emotions very seriously. It takes our passions very seriously. But it says our passions have to be correctly ordered. So something like love. Love is a passion of human beings. It's one of the things that makes us human. But it has to be ordered correctly. Because if it's not ordered correctly, it becomes very destructive, not just to other people, but to ourselves as well. So natural law, that's essentially what it is, and it has very big implications for things, how we think about law, legal systems. It has very big implications for how we think about the nature of political order, what the role of government is. It has implications for how we think about ultimate truths, including the truths that are knowable through faith. And what's also interesting about natural law is that as C.S. Lewis, the literary writer and philosopher and somewhat of a theologian, put it, it's something that all people in all cultures can know, and that all cultures have some inkling of this idea of natural law. It's more sophisticated and more developed in particular cultures and particular religions than others. But nonetheless, if you look at most cultures, you can find this type of thinking, which speaks to its universality.
That's exactly my second question, which was, I think a lot of people associate natural law theories with Christianity and maybe Catholicism.
Particularly Catholicism.
And so is that a necessary combination?
No, not at all, because, as I like to say, the first two people who we would describe as recognizably natural law thinkers were Plato and Aristotle. The last time I checked, they weren't Christian. They were pagans, right? If you look at the Stoic philosophers, many of whom were Greek, some were Roman, or the Roman lawyers who were writing before the advent of Christianity, there's clearly natural law reasoning that's built into the way that they think about the world, and they were very much opposed to those people who were the skeptics of their time, the people called the sophists. So natural law is not intrinsically linked to religion per se, or Christianity in general, or Catholicism in particular. That said, it is the case that natural law theory has been most developed in its most sophisticated forms, primarily within Christianity, and I would say, I think it's pretty obvious, within Roman Catholic Christianity in particular. I mean, the greatest natural law thinker who most people, whether they agree with natural law or not, would recognize is Thomas Aquinas. So he's the angelic doctor, as they call him. And his Summa Theologiae, which is his writings, his main writings, particularly the treatise on law, is still the primary reference point where most people begin, even if they're an atheist, when they start talking about natural law.
Talking about St. Thomas Aquinas, obviously he was in conversation with other people.
Yes.
He was addressing not only, I guess, students, but other people, engaging them in discussion about natural law. What was the environment within which he was developing his theories of natural law?
Well, when Aquinas was writing about natural law, so we're really talking about the 13th century, there were immense controversies going on in medieval Europe, which is overwhelmingly a Christian world, about questions like the nature of reason, the nature of will, but also the question of how do we incorporate or how do we deal with the writings and thoughts of people like Plato and Aristotle, who are now being extensively studied in medieval Europe at the time. And this was a challenge for the church at this point to work out how do we reconcile the truths of revelation. So revelation is what God gives us in terms of special revelation for Christians, it's through the person of Jesus Christ, through the Jewish and Christian scriptures, etc. But there's this whole discussion about well, what do we do with these pagan philosophers and their particular understanding of reason, which has been so important in shaping the culture in which we're living? And it was by no means certain that a reconciliation of these positions was going to be carried out, because there were a lot of people at the time who were very suspicious of people like Plato and Aristotle because they were pagans. They were pre-Christian thinkers. Now, in the first 5 centuries of Christianity, this had been dealt with very well. There were people, St. Paul even talks about this in his letter to the Romans, how the Greeks can know the truth that's written on their hearts, even though they have not had Christ revealed to them, etc. But within a century of the beginning of the Christian church, you see Christian philosophers, that's how they called themselves, grappling with some of these deeper philosophical questions. Augustine does a lot of this, and Aquinas is really doing this in a context in which there's renewed interest in Aristotle and Plato. There's also debates going on about how free human beings are, what is the nature of freedom, how does the will and reason of humans relate to the will and reason of God. These are big questions, and there were plenty of people saying at the time, God is just pure will. So we just obey. And people like Aquinas were saying, no, God is will, but God is also logos. Logos is the Greek word which means divine wisdom. And that's how the Gospel of John begins, right? In the beginning was the Word. It's really, in the beginning was the logos. That's the Greek word that's used. So Aquinas is engaged in an exercise in recovery of these ideas. He's engaged in an exercise of combating particular ideas, particularly voluntarism, the notion that God just wills, but also what's called nominalism, that things only have meaning and content to the extent that we give them meaning and content, which means that things have no meaning of their own. There are no things that have objective truth in themselves until we give them a name, hence the nominalism. That's where that comes from. So these are some of the debates that Aquinas was having at the time. His great intellectual master was Albertus Magnus, who was some people would regard as the founder of the modern sciences in many respects. But he was wrestling with these questions as well, and Aquinas wrote his Summa Theologiae as a way of providing predominantly Catholic clergy with instruction about how we think about reason and its relationship to faith, how we apply natural law to the political, legal, and economic order, and how natural law relates to other types of theological questions that need to be addressed as well.
And then came, many years later, the Reformation. And there's a Protestant tradition of natural law and the Catholic tradition of natural law.
That's right.
Is there a break? Is there a difference in the way that they focus on issues?
Yes, there is, but it's less about Protestant versus Catholic. It's much more a different type of reasoning that was going on compared to what was going on in the medieval world. So if you look at the writings of Spanish scholastics, people like Francisco Victoria, people like Domingo de Soto, some of the people who are up on pictures around here at Francisco Marroquin, they were wrestling with some of the questions that were posed at their particular time. Things like with the encounter of Europeans with the New World. What does this mean for how we should treat these people in the New World, who are very different to what we look like? They were also dealing in a time when you have the emergence of modern sovereign states, which really didn't exist in the medieval period. That's a very modern idea. They're dealing with the question of how do these states relate to each other? So you see them developing theories of international law, for example. They're also asking questions about, with the emergence of the modern state, what does this mean for the freedoms and liberties of people who live within a particular community? So this is where you find notions of human rights first starting to be developed in a sophisticated form. But you see the same thing happening in the Protestant world. So you have Protestant thinkers like Hugo Grotius, who many people would regard as the modern father of international law, who also was a very strong advocate of free trade. He had a whole natural law argument in favor of free trade. You had people like Samuel von Pufendorf, who were writing about these things in terms of the relationship of states between each other, but also the relationship between the people and the state. You had people like Aimé de Vattel, who wrote a book called The Law of Nations, which is really the first codified attempt at producing a book that you could look at and say, this is what international law consists of. So they're not arguing about the place of Scripture in Revelation. They're not arguing so much about whether the Pope is infallible or not. They're not arguing about questions of, do you have bishops, do you have priests, these sorts of issues. I mean, those arguments were going on, and many of these things very much defined the whole Reformation movement and the Counter-Reformation that came from the Catholic Church. But when it came to natural law, there are subtle differences, but nothing like the sorts of fights that were going on. So the wars of religion were not about the place of natural law in Christian belief and Christian practice or in communities in which most people were Christian. Natural law had nothing to do with any of that. So you see, and what we also know is that many of these Protestant thinkers and these Catholic thinkers were reading each other's work. And we know that because they're citing each other at the time. Mm-hmm. So for people in the post-Reformation world, natural law was simply part of the mental universe in which everyone lived, whether they were Roman Catholic or Protestant. Everyone thought this way. The legal systems reflected this. The actions of governments reflected this. The laws and codes that governed trade reflected some of these things. Now, that doesn't mean they got everything right, because there were arguments about, okay, well, are the native peoples of the new discovered world, are they really human? Mm-hmm. And that mattered, because if they weren't human, then you could treat them one way. On the other hand, if they were human, then suddenly you couldn't do all sorts of things that were already being done to them. So this is why many people would argue that it's really with natural law that the first coherent theories of human rights start to emerge. Very different to the way human rights are talked about today, but nonetheless, this is very clearly the roots of these things.
Why is the treatment of human rights, I think everybody in our time is very accustomed to mm-hmm. talking about human rights. And we are really abusing, I think, the term with second, third, and fourth mm-hmm. generation of human rights. But why is natural law theory so important to ground a sound understanding of human rights?
Well, one of the major problems we have in much political discourse today, you've already sort of inferred this, is that people invoke the language of rights for everything. I have a right to my dog. I have a right to this. I have a right to that. You may not do this to me because it's my right to not have that done to me. Rights is the ultimate trump card in much political discussion that's used as a way of extracting things from other people. Because once you make a rights claim, it becomes very difficult to say, well, no, you can't have that. But it's my right. You must give it to me. So that's one part of the problem. The other part of the problem is that rights have become detached from any sense of objective moral norms that can be known. And in fact, many secular organizations that use the language of rights freely admit this, that their conception of rights is highly subjective. So it's got nothing to do with reason. It's got nothing to do with our capacity to know universal moral truths. It's much more about getting your way. And the other part of the problem is that so much political discussion now has degenerated into sort of rights talk and people invoking rights against each other all the time to try and get their way, rather than thinking, okay, what does our reason tell us that tells us that this claim is a right, but this claim is not, in fact, a right. Natural law provides that. Natural law provides us with the ability to do that because it grounds rights upon these objective moral goods that we can know through our reason and then freely choose. So let me give you an example. Let's say the right to religious liberty. Now, the right to religious liberty from a natural law standpoint is not the idea that I get to believe whatever I want and it's all about my subjective opinion, my feelings. It's all about me. No. A natural law claim for religious liberty is based on the idea that there is truth, that our minds are wired for truth, including religious truth, insofar as that religious truth is about those ultimate realities, about whether there is or is not a God. If there is a God, who is this God? How do we know this God? And what does belief in these things, the meaning that has for our actions? Natural law says, well, that's why you have a right to religious liberty, because you can't know these truths or pursue these truths or live these truths unless you have a certain protection that's accorded to you for doing that. By the way, this protects atheists just as much as it protects the religious believer, because the atheist can say, well, I don't believe there is a God, so that's their truth claim. That's the truth claim that they're making about religion, and therefore you can't coerce me to go to synagogue or go to mass or go to church or whatever it happens to be. But religious liberty in this natural law context is based very much on a natural law understanding of human persons and the implications of that for the role of the state vis-a-vis religion. It's most wonderfully spelled out in the Second Vatican Council's Declaration on Religious Liberty, Dignitatis Humanae, which is pretty much pure natural law argument for religious liberty.
One phrase that I read in your text is, and it really captured me, is the natural law ethics understands justice as a virtue. Can you explain? Because as with human rights, I think justice has been very distorted, our understanding of justice.
No, that's true. So if you read Aristotle or if you read Thomas Aquinas, there are 4 cardinal virtues: prudence, courage, temperance, and justice. What makes justice different from the other 3 is that by definition, justice has a social dimension. So we're not just to ourselves. When justice means acting correctly vis-a-vis other people. So justice is a little different from the other 3 virtues because it has this inherently social character. You can't even conceptualize it without this inherent social character. Now, so how that cashes out in natural law terms is that you have general justice, which is a commitment to the common good, which breaks down further into commutative justice, which is the relations that are mainly carried out vis-a-vis contracts, freely agreed agreements that we enter into. And then you have distributive justice, which is about how we distribute things justly within a given society. So natural law has a very clear understanding of what all these things mean. And that's why, so if you look at natural law conceptions of justice, they basically reflect a working out of these 3 main ideas of justice: legal justice, the big one, then you've got commutative justice and distributive justice. And if you look at most legal systems, even ones not based on explicitly natural law premises, that's basically how they work. But natural law provides you with a way of showing how these different modes of justice relate to one another. They remind you that you can't, for example, just say, well, there's just commutative justice and that's it. No, there's also distributive justice and this broad sense of what is often called legal justice or general justice. The other thing about natural law conceptions of the nature of justice is that it's ultimately concerned about truth. It's not about it's not a conception of law as just being a matter of social fact, which is what positivists say. And positivism is, of course, the dominant way that most legal systems function today. And that just says that law is a matter of social fact, justice is a matter of social fact. It's not so much about what is good and what is evil, what is right and what is wrong. And natural law challenges that and says, no, there is a legitimate place for the state to be decreeing laws and working out what these modes of justice mean, but they don't do so outside a particular moral framework that we call the natural law. So natural law prevents justice from being taken off in very subjectivist directions. It provides a way of thinking about how different modes of justice relate to each other, but also how they relate to this idea we call the common good. And it adds a general coherence to the whole functioning of not just what people get from the legal system, but the way the legal system functions itself. So we think about something like rule of law, for example. Natural law doesn't say that rule of law is simply just non-arbitrary behavior. It says rule of law believes that we should not have people acting, we should not have institutions behaving in an arbitrary manner because it is unreasonable for that to happen. And natural law even provides different criteria by which you can assess whether a state of rule of law exists or whether a rule of law does not exist. And it's really about, in that respect, the natural law conception of rule of law, which is so important for any just system, is grounded upon the idea that there are reasonable ways of acting and choosing and there are unreasonable ways of acting and choosing, and judges and legislators are just as bound to act justly when they're doing their jobs as the rest of us.
So you've mentioned rule of law, and I tend to think of rule of law and limited government sort of going together. And
Yes.
Do you think the natural law ethics is more compatible with limited government and rule of law than with a very interventionist and a big government?
Yes, I do. And so did Thomas Aquinas. So Thomas Aquinas, Lord Acton, I think it was Lord Acton, described Thomas Aquinas as the first Whig, W-H-I-G. And by Whig is meant this idea that the government does not have absolute power. There are limits to what the state can do. But the natural law explanation of these things is not that, it's not an argument for liberty for its own sake. It says that the state must be limited. Legislators, judges, anyone who is in a position of authority cannot do whatever they want. One, because to do so is to engage in arbitrary behavior, which is classically defined as the rule of men rather than the rule of law, which means acting according to your passions rather than acting according to reason. So that's one thing. The other thing is that natural law, as I think I mentioned before, takes free choice extremely seriously. So while natural law is not a position of anarcho-capitalism, it does believe there is a role for government. It does believe that the judiciary and the rule of law are very important and play important functions in society. But it also recognizes that there are limits to what the state can do in terms of helping people to flourish, because you can only flourish, you can only become more virtuous, which is the goal, if you freely choose to do so. So if you're trying to be a more prudent person or trying to be a more courageous person or more temperate or more just, no one can make you do that. You have to, at some level, make that free choice for yourself. So then the virtue becomes part of who you are. And it becomes part of who you are through you making this free choice for the good. So what that means is that at some level we have to accept that there are people who will not make free choices for the good, and there are limits to the degree to which we can coerce them not to do that. So, and there's arguments in natural law about where those limits lie, but what's not in question is that there are distinct limits to these things. So the natural law conception of rule of law, the natural law conception of the state, very much points in the direction of limiting the power of these institutions, not in a sense of a sort of night watchman state, but putting principled limits about what state officials and the state itself can and cannot do. And that's one of the things I try and explain in more depth in this relatively short monograph, which is written for people who, I'm assuming, no knowledge of natural law, for the people who read this. But that's one of the things about natural law. I think even a lot of people who believe in the free society are not super conscious of just how much free societies owe to natural law. I think it's very difficult to explain the emergence of constitutionalism, of rule of law, of concepts of rights, of concepts of limited government. I think it's really difficult to explain these things without this bigger natural law background.
How about property rights?
Well, that's another one, right? Because if you look at property rights, natural law says, yes, there are property rights. They're not absolute. There are goods, because property, it consists of things we own. They're not human in themselves. And natural law doesn't say that that property rights can be invoked to basically stop people from doing anything. Natural law doesn't translate into no taxation, for example. But what it does do is say that in any given society, there's wealth, there's goods, there's things around, and we need a way to organize how these things are put together. And natural law says that private property is, in most circumstances, the optimal way of doing that, for several reasons. And this is Aquinas drawing directly upon Aristotle. I mean, it's almost word for word. But he says things like, Aquinas says, following Aristotle, if everything is owned in common, then no one is responsible for anything. So that's one thing. He also says that people tend to take better care of things they own than if they don't. So he goes through and gives these different reasons for why private property is not just licit, as in sort of just grudgingly conceded. It's the normal state of affairs. Now, it also says that in our use of our goods, it needs to be outward directed. We have to take care of our needs of our families and things like that. But our use of our property is not exempt from the demands of natural law, from the moral law. But even then, we still need that freedom to make those choices about how we use those things so that they benefit ourselves and others at the same time. So it has a pretty strong position on natural law. It's not the position of that property rights are absolute, but it says they're very serious things and you need to have very good reasons for overturning them at any one point in time. And when you do have to do that, you should want to revert back to normal circumstances as soon as possible.
Well, I'm very happy that Fraser Institute asked you to write this book, because I think the ideas of natural law really have fallen in disrepute, or they've been neglected, or maybe just ignored. And so we seem to live in an era of moral relativism, or this post-truth reality. How do we get them back into our language and into our classrooms?
Sure. Well, doing interviews like this, writing little monographs on the subject. Well, but I think there are very practical ways. First of all, one of the things I point out in the monograph is that the functioning of our legal system depends in so many ways upon basic principles of natural law that are simply built into the functioning of the legal system, even if we don't even acknowledge it. So things like due process, right? So due process is based upon the idea that there are reasonable ways of treating people and there are unreasonable ways of treating people. So the moment you invoke the language of reasonability and unreasonability, you're saying that reason can recognize that there are good ways of acting and there are bad ways of acting. That sounds like a natural law position, so I often use that. I will often say things like, I want you to imagine a society in which claims of natural law are just completely pushed aside. What's left? And what you realize very quickly is that you're basically left in a situation whereby laws are not decided on the basis of what's reasonable, what's unreasonable, what's just, what's unjust. What matters is power. Who has the power? Whether it's power of electoral majorities or the power of the gun. Because that is really the only alternative to a legal regime, a political regime that is not at some level, informed and guided by natural law principles. It's also a very important protection for human freedom, because if everything really is relative, then there's no in principle reason why I wouldn't do seriously evil things, apart from the fact that I might be scared that other people might hurt me. But we don't live in those types of regimes, so we are actually living, I think, certainly our legal systems to an extent do reflect much more of this natural law legacy than we realize. It's also important to remember that it's only over the past 100 years that natural law has faded from a lot of political and legal discourse. There's different reasons for why that's happened, and some of it's to do with the decline of religion in particular societies. But I do think at some point it's very hard to avoid the conclusion that the reasonability of these systems depends so much upon some level of acceptance of natural law. Now, natural law scholars, I should mention, argue all the time about things like, well, is this a right or is this not a right? Is this behaving virtually or is this not behaving virtuously? They also spend a lot of time looking at what are called hard cases, where it appears that there's really no good option. And they spend a lot of time thinking through, okay, well, how do we arrive at what is the good and proper way of acting when it seems like no options are good? So I don't want to give people the impression that people who adhere to natural law thinking agree about everything. In fact, I make that point that they don't. They don't agree about everything, particularly when it comes to the prudential judgments, which are basically decisions that are different, but they're both just, right? So that's extremely important. But where they do agree is the idea that we have reason, we have the capacity for truth, we can know what moral truths are, and there are basic principles that are binding in all situations. So I think when you alert people to some of these things, they start to realize, oh, okay, well, I'm not sure I actually want to live in a world where there is no natural law, but also people live their lives on an everyday basis by adhering to principles of natural law, even if they completely dispute the whole idea. So things like the way we treat our parents, even things like, so the 10 Commandments, particularly the second Decalogue, don't kill, don't steal, don't lie, etc. Natural law provides us with whole arguments for why that is the case, and most people live by those things on a daily basis without even thinking about them. So there are lots of different ways, but I do think that imagining a world in which there is no natural law, in which the state is the institution that decides what's right and what's wrong, in which people get to willy-nilly decide by themselves what's just and what's not just, it's a pretty dark world. So I think even someone like Hans Kelsen, who was probably the foremost legal positivist of the 20th century, towards the end of his life, he sort of basically admitted that there is a type of natural law. He sort of admitted it. But interestingly, he thought, well, of course, that raises other questions, because if there is a natural law, then that points in the direction of the whole God question. And he said, any attempt to think about that is basically a fallacious exercise, to which the response is, why? Why? It's a natural thing that you should be asking. If there is order built into the universe, if there is order that's part of our reason itself, if there is truth and good and evil and right and justice and injustice, and that comes from natural law, then we inevitably at some level start saying, where's this come from? And you know what? Evolutionist arguments don't cut it.
On that note, thank you, Sam. Thank you so much. This is really interesting. We're really looking forward to reading your book, The Essential Natural Law. And thank you so much for sharing some of its content with us today.
Well, thank you for having me, and thank you for all the work you do at Fay Libertar. And I know you guys take natural law very seriously, so it's always good to talk to people who understand its importance for a free society.
Thank you, Sam. And to all our friends who are watching, be sure to follow us on our social media. So don't miss out on any of our content. Thank you very much for joining us, and see you soon.